Good evening. Tonight we start with important developments in an ongoing legal matter. Reliable sources have provided access to what appears likely to become a key element in the prosecution's arguments against former President Donald Trump. This involves an actual sound recording in which the ex-president can be heard discussing and apparently displaying a strictly confidential file outlining American military options concerning Iran. He does this in the presence of individuals who held no authorization to be aware of the file's existence, much less its contents. In just a short while, viewers here will listen to the very material that jurors may one day consider in court. The conversation took place during the summer of 2021, specifically in July, inside the former president's property in Bedminster, New Jersey. The voices are distinct. Trump addressing a small group. Court documents from the special counsel indicate the listeners included an author assisting with Mark Meadows' book project, the book's publisher, plus a couple of staff members from Trump's team. Importantly, the former president realized the discussion was being captured on tape. This marks the initial public release of that recording. Recent reports have drawn attention to a pivotal audio clip expected to carry substantial weight in the federal effort directed at Donald Trump. In it, the former leader speaks freely about a top-secret paper detailing potential U.S. military action toward Iran, all while addressing people lacking any security clearance for such information. Captured back in July 2021 at his New Jersey club, the tape will soon be available for you to hear, exactly as it may be presented in a courtroom someday. On the recording, Trump's voice is unmistakable as he converses with that select group, the memoir writer, the publisher, and members of his inner circle. He was fully conscious of the recording device, and today represents its first open broadcast. What stands out most in today's update is genuinely striking. It fundamentally alters our perspective on the entire controversy surrounding Donald Trump's management of sensitive government materials. This goes far beyond speculation, partisan accusations, or accounts passed along by opponents. Instead, we have the former president's direct statements recorded live in what he believed was a completely private setting, with no expectation that the discussion would ever reach the outside world. The combined audio and written records paint a clear picture. Trump demonstrated full awareness that he possessed materials bearing classification markings and that he had taken no formal steps to lift those restrictions. Moreover, he explored options for sidestepping a formal government demand, a subpoena, requiring the return of those items. This matter rests not on supposition nor on assembling scattered public details. At its core, it relies on the former president's recorded remarks, which stand in direct opposition to the explanations he has consistently offered in public settings. Add to that the careful, contemporaneous records kept by his legal counsel during sessions where strategies to impede a federal inquiry were apparently discussed. A notable aspect is that certain exchanges originally considered shielded under attorney-client confidentiality eventually became accessible to investigators. That protection dissolved after a federal judge examined the material and reached a reasoned determination. To explain plainly, typical discussions between a client and attorney enjoy strong safeguards, allowing open and honest legal counsel without fear of later exposure. Yet when a court determines that those exchanges may have served to advance unlawful conduct, a specific doctrine, known as the crime-fraud exception, removes that barrier. This principle, applied infrequently, holds that communications intended to facilitate crime or fraud lose their confidential status and may be obtained by authorities. Investigators continue tracking significant progress in separate inquiries focused on former President Donald Trump. One centers on a grand jury process underway in Manhattan under the local district attorney. The second concerns the special counsel's examination of how classified records were managed following his time in office. According to individuals familiar with the proceedings, a federal district judge issued an important decision in the latter matter. The judge concluded that prosecutors under special counsel Jack Smith had submitted sufficient material to indicate the former president may have engaged in criminal conduct involving his legal representatives. As a result, at least one attorney from that circle could be required to appear and provide testimony to a federal grand jury. It prompts serious reflection when we consider the implications. The public generally views lawyer-client discussions as strictly private, and for good reason. That confidentiality forms a fundamental protection in our justice system, designed to promote candid advice, seeking without concern that statements might later be used adversely. Judges approach any breach of this principle with great care, ordinarily demanding compelling proof that the relationship was exploited not for proper guidance, but to conceal or further illegal acts. Precisely that threshold was met here. Chief Judge Beryl Howell, after careful review of the presented material, determined the standard had been satisfied. Parallel developments are unfolding in those two distinct Trump-related probes, the New York grand jury effort and the special counsel's classified documents inquiry. Informed sources report that the district judge ruled special counsel Smith's team had met the burden to demonstrate potential criminality linked to Trump's interactions with counsel. Consequently, one of those lawyers now faces the prospect of testifying under oath before a grand jury. Further, the judge determined that certain consultations appeared connected to possible efforts to interfere with justice. On that basis, she directed the turnover of more than 60 pages of the attorney's handwritten records and summaries to the prosecution led by Jack Smith. These documents capture private exchanges between the former president and his counsel, material that would normally remain shielded but was ordered disclosed to support the building of a case. Such an override of attorney-client protection is far from routine. It requires substantial grounds indicating criminal purpose. Courts recognize the importance of the privilege and issue these orders only when the record convincingly supports it. Those 60-plus pages, together with the audio in which Trump acknowledges retaining classified items without having removed their protected status, now form cornerstone elements for the government. Special counsel Smith has informed congressional oversight that his office possesses evidence sufficient to meet the beyond a reasonable doubt threshold for conviction. Today, the focus turns to those two pillars: the Bedminster recording capturing Trump's unfiltered statements and the attorney's detailed notes outlining conversations about the subpoena and the retained materials. These are not interpretations shaped by outside agendas or political motives. They reflect the former president's own expressed views and intentions, preserved in his voice and through his lawyer's immediate documentation. Hearing the content directly and understanding the judicial reasoning that permitted its release makes evident why the special counsel maintains this matter satisfies the strictest evidentiary standard in American law. The strongest elements arrayed against Trump originated not from outside probes or third-party accounts, but from his own unguarded moments in environments he considered secure. Consider the audio captured during that July 2021 gathering at the Bedminster Club. In dialogue with aides and a writer, the former president effectively undercut the central claim he has advanced repeatedly on the classified documents question. Publicly and consistently, he has asserted that all such materials were declassified prior to the end of his term, a position repeated across platforms, interviews, and public events in an effort to shape opinion. He maintained that presidential authority allowed unilateral declassification, rendering any post-tenure possession lawful and casting doubt on the premise of the investigation. While that position carried certain risks, it might have held sway with some fact-finders. Yet the recorded conversation presents a starkly different account. Trump explicitly refers to a particular military planning document tied to potential operations involving Iran as remaining highly secret and tightly controlled, employing terminology reserved for the government's most guarded information. Most critically, he states that while in office, he possessed the power to declassify such a file, but no longer does. That candid admission, made casually in what he viewed as a trusted circle, fundamentally erodes the foundation of his public stance. The gravity of the statement is difficult to overstate. It is striking that these words were uttered at all. Imagine the scene. At his golf property, Trump handles a document infused with national security sensitivities, one plainly unsuitable for display to unauthorized persons. He acknowledges its ongoing classified nature and recognizes that, outside the presidency, he lacks authority to change that status. Such a remark directly contradicts months of assertions that declassification had occurred universally before departure. The two positions cannot logically coexist. This recording reveals Trump's genuine understanding in a moment free from public scrutiny, expressed in his characteristic informal style. Turning to the written record compiled by attorney Evan Corcoran, who represented Trump amid the classified document scrutiny, these memoranda may carry even greater force. While the audio establishes awareness of classification, the notes indicate active contemplation of methods to avoid complying with the government's demand to surrender the materials. Corcoran documented his interactions contemporaneously, lending the accounts high reliability as opposed to later recollections. They offer immediate snapshots of discussions on responding to official requests. The content exposes attitudes, responses to the subpoena, and contemplated approaches that appear highly significant. In those sessions, Trump reportedly showed limited interest in standard compliance strategies and greater focus on avoidance. Suggestions reportedly included simply declining to engage or refusing cooperation entirely, notions that could imply intent to disregard a grand jury directive, potentially inviting contempt findings or added obstruction claims. More troubling still, questions arose about whether it might be preferable for the materials to disappear altogether, language interpreted by some as hinting at possible destruction rather than turnover. Fairness requires acknowledging that interpretations vary. Supporters could frame these as innocent inquiries from a client navigating unfamiliar procedures, absent any illicit design. Chief Judge Beryl Howell, however, after thorough examination of the notes within their full context, rejected that benign reading. She found the exchanges aligned more closely with potential obstruction than legitimate consultation. Invoking the crime-fraud exception, she compelled disclosure of over 60 pages of those records to Special Counsel Smith's team. Beyond that, she required Corcoran to testify before the grand jury concerning his confidential discussions with Trump, placing an attorney in the extraordinary position of providing evidence potentially adverse to a former client. Such compulsion arises solely when a court concludes the privilege has been misused to shield criminality rather than to secure proper counsel. Together, the Bedminster Audio and Corcoran memoranda create a formidable body of material. Each element bolsters the others, forming a narrative exceptionally challenging to counter, regardless of defense resources. The recording confirms Trump's knowledge that the items retained classification and remained undeclassified, directly contradicting his public narrative. The notes, meanwhile, capture explorations of subpoena evasion, including speculation about elimination of the items. Prosecutors view this pattern as indicative of consciousness of guilt, conduct suggesting awareness of wrongdoing coupled with attempts to evade accountability. A truly innocent holder of mistakenly declassified material would have no reason to contemplate ignoring legal process or contemplating their absence. Such expressions point to recognition of legal jeopardy and efforts to mitigate consequences. These items anchored charges of willful retention and obstruction in the classified documents indictment, establishing not merely possession but knowledgeable retention, absence of declassification authority, and active steps, or at least serious consideration, to prevent recovery pursuant to lawful order. Stepping back, the significance of this audio and these notes extends well beyond the immediate counts. They fundamentally redefine the broader landscape of legal exposure facing the former president, past, present, and potentially ahead. No volume of political commentary, procedural maneuvering, or criticism of investigative actors can diminish their force. That durability explains their exceptional influence. Much of the investigative record derives directly from Trump's own sphere, unmediated by adversaries, unfiltered through outlets he frequently disputes, and untainted by external narration. Here stands his voice on tape, plainly affirming a document's continued classification and his current inability to alter that status. Here, too, are contemporaneous lawyer notes recording real-time exchanges on subpoena navigation, including musings about document disappearance. This internal, self-generated material proves exceptionally difficult to discredit. The defendant effectively becomes his own most damaging source. No jury easily disregards a defendant's recorded voice. Prosecutors characterize the Bedminster tape as a classic smoking gun, one voluntarily provided without coercion. In classification and retention prosecutions, establishing mens rea, the defendant's state of mind, often presents the greatest hurdle. Questions persist. Did the individual comprehend the classified character? Did they recognize post-presidency possession as unlawful? Or did a genuine, albeit mistaken, belief in declassification or retention rights exist? Ordinarily, such intent must be inferred through indirect proof or expert analysis. With this defendant, no inference is required. Direct evidence exists, his own recorded admission that the material remained classified and that declassification power had lapsed. Few forms of proof carry greater clarity or persuasiveness on the issue of knowledge. Thus, the Bedminster exchange captures unguarded acknowledgement of facts fatal to any ignorance defense. Coupled with the crime-fraud determination, which dismantled confidentiality barriers and exposed the notes, the ruling carries weight far beyond this single matter. It provides not merely evidentiary access, but an authoritative judicial assessment. A chief federal judge, acting impartially, concluded the attorney discussions veered toward obstruction rather than lawful guidance. That finding, neutral and evidence-based, joins more than 60 pages of notes in the official record. Special Counsel Smith has represented to Congress that the totality satisfies the beyond reasonable doubt standard for conviction. Future proceedings inherit not only raw material, but a pre-existing judicial rationale explaining the loss of privilege, a signal that credible grounds exist for viewing the consultations as instruments of obstruction. Crucially, this evidence endures. It remains preserved, verified, and positioned within the case file, unaffected by shifting news cycles. Should protective status change and renewed action become viable, the Bedminster recording, Corcoran notes, crime fraud ruling, and associated judicial findings stand ready, obviating any need to reconstruct foundational proofs from zero. The former president need not have prosecutors hunt for incriminating material. He supplied it himself. The tape exists because he chose to display sensitive military planning to impress non-cleared acquaintances at his club. The notes survive because candid discussions with counsel crossed into territory a judge deemed indicative of criminal purpose rather than privileged advice. In each instance, the most potent case elements emerged from Trump's own actions and statements, unprompted revelations made in presumed safety. That tendency to speak freely, boast, or scheme audibly in trusted settings has produced enduring consequences. The government's most compelling instruments are those he placed directly in their hands: authentic recordings of his voice, preserved admissions now embedded in the permanent record of federal justice. No advocacy, no executive action, no pardon can erase spoken words captured on tape at Bedminster or documented in private legal sessions. Those declarations persist, inescapable, accompanying Donald Trump indefinitely. Whatever political fortunes unfold, whatever duration of executive insulation remains, the core incriminating material stems not from external discovery but from self-revelation in unguarded moments. That reality lies at the heart of this account. If this analysis proved useful, please consider liking the video and subscribing for ongoing coverage. Developments here continue to evolve and updates will follow closely. Stay tuned. More is certain to emerge.